Hi there, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our weekly immigration show. And if you haven't already, smash that like button because it helps with that YouTube algorithm, actually YouTube, because it allows people to see the videos more often like yourself. So I'm representing clients throughout the 50 states and J1 waivers. We have clients throughout the 50 states. So today, what we're talking about are what's going on with the J1 waivers, our most recent success story, processing times. It's very, very cool, interesting stuff. So you're gonna wanna stay tuned. All right, let's, first of all, before we dive into the success story, I wanna lay the foundation for you on the J1 exceptional hardship waiver. How do you qualify? How do you make it happen? Well, you have to have a U.S. citizen spouse, lawful permanent resident spouse, or a U.S. citizen or lawful permanent resident child. Now you might be like, what? I don't have either. What do I do? Well, you look at an interested government agency waiver. Specifically, if you're a physician, you could look at a Conrad 30 waiver, a VA waiver. Also, no objection waiver. Now, no objection waiver, I see a lot of people before they come to me, and especially recently, waste a lot of time applying for a no objection waiver. For instance, when you have government funding, ends up getting denied. And make sure if you're gonna do a no objection waiver that you connect with your home country's embassy to make sure that they're willing to issue a no objection statement. Otherwise, you're wasting your time. And so I wanna make sure that you know about those options too if the exceptional hardship waiver is not something that will work for you. Now, let's talk about the process. So the process is filing an application with the Department of State. We simultaneously file the I-612 with USCIS, and we submit a detailed legal brief outlining the hardships to your U.S. citizen or lawful permanent resident spouse or child. Submit that. USCIS then will review the case, and then they will pass it on to the Department of State. If Department of State approves it, then they'll send it back to USCIS for final approval. Now, if you have US government funding, the Department of State will also ask for sponsor views. So let's make this relevant to you. Let's look at what this is like in the real world, because this is great, like a bunch of hypothetical information, but let's talk about like how did this play out in a specific case that we had. Now, I want to share some news with you about the time that this case took overall. It took almost 2 years. Our average times are around 1.5 years, and it's slowing down. I do not know why. Well, I do know why. Department of State is taking longer and longer. I think it's because of COVID. They have this tremendous backlog, and they're the agency that are slowing it down. It's not mostly on USCIS's fault that is causing the delays, primarily Department of State. In this specific case, we filed the case in July 2020. So a little bit less than 2 years. It's not totally a 2-year time count, but we filed July 2020. USCIS issued the I-613. USCIS transferred the case to the Department of State on January 2021. Then, now, this is the part that I was talking about earlier, how Department of State delays processing, not delays, they're just taking a long time processing the case. So even though it was transferred to them in January 2021, they did not issue a favorable recommendation. All right, everyone, get ready for this, until May 2022. So the favorable recommendation was not issued until May 2022. We are still waiting for the final approval from USCIS. I'm hoping, as I shoot this video, it's June 2022. I'm hoping we'll get it in June. But if it's not issued till July, then it will be actually 2 years. So you can see how long this whole process is taking. And that's why, and I'm happy that I'm talking to a lot of people now who are planning ahead, to make sure that you plan ahead to give yourself plenty of time to apply for the J1 waiver, because that way you can get the benefit out of it. Otherwise, if you wait too long, you might have to leave to go home, or you might have to look at other options to stay in the United States, and those options can be limited. Now let's get to the exciting part. We are going to look at a success story. So here the applicant, he was from India, his wife was a US citizen. The client came in on the J1 program, it was good for 1.5 years, and then overstayed their J1 visa. Then after that ended up marrying a US citizen. Not only did he marry a US citizen, but they also had a US citizen child. Now, the client had been in the United States for well over a decade. One argument that we made was financial hardship. So the applicant was the primary caregiver while the spouse went to work. So how we also, when we make these financial hardship arguments, one factor that you can look at and what we made this argument, how we made this argument was based off of, well, what would the cost of daycare be if he wasn't doing childcare? So that would be very expensive for this couple and not affordable, and that's the argument that we made. Not only that, but we also argued health hardship. So in this situation, the client, this US citizen spouse, also had chronic back pain, neck pain, and we were able to show that our client was seeing a chiropractor. We got a letter from the chiropractor. It's really important that you're able to provide documentation that supports your exceptional hardship claim. Otherwise, it's just a claim, so you need to provide the supporting documentation as well that proves your exceptional hardship. Here, the chiropractor also talked about the need of the support of the spouse as well. And that letter from the medical professional is extremely important. And not only that, we also like to include country conditions too. So in this situation, we talked about the country conditions of India as well. And then we put that all together, stacked all of those arguments, and boom, we were able to get an approval. So these cases are a lot of work. They do take a lot of time to prepare. They do take a lot of research, and it's something that really we like to do in a detailed legal brief to make sure that we know that at the end of the day, we felt like we did everything we could to get it approved, because we know the consequence. If you get the case denied, then you have to go back for 2 years, and that can be very challenging, to say the least, for many of you. I want to thank you for taking the time to watch this video. Make sure you subscribe so you can continue to get these updates and get the notifications so you can find out the latest. And I honor you for everything that you're doing, for all the challenges that you've overcome by being here in the United States. Now you have to file this J1 exceptional hardship waiver possibly. So you've gone through a lot, and you're truly amazing for everything that you do. Thank you. Bye for now.